Donald Trump just got more bad news in court from Judge Eileen Cannon. Yep, you heard that right. In the Mar-a-Lago document case in federal court in the Southern District of Florida, Judge Eileen Cannon just issued an order denying Donald Trump's motion to dismiss the superseding indictment based on the Presidential Records Act. This is the motion to dismiss filed by Donald Trump, where he claimed that he could telepathically declassify any records while he was in office, and by putting it in a box and shipping it to Mar-a-Lago, our nuclear codes, our nuclear records, our war plans, and any other classified information thereby becomes his personal property, and neither courts nor juries can second guess his classification. He was saying the Clinton Sox case says that I can do it, referring to a district court case, not even a circuit court case in Washington, D.C. that had nothing to do with any of the issues here involving the Espionage Act. That Clinton Sox case involved that guy Tom Fitton, who's not a lawyer, who runs the group called Judicial Watch, a far right-wing group. They sued the National Archives back in around 2011, 2012, asking that they force former President Clinton to turn over his personal notes that he created for his autobiography. And the federal court in Washington, D.C. rejected that. And somehow Donald Trump claims that that case involving Bill Clinton's personal handwritten notes for his autobiography somehow allows Trump to violate the Espionage Act. Well, Judge Cannon rejected that based on the four corners of the way the indictment is pledged. She does have some cryptic messages in here that I want to share with you to still show you the mischief and nefariousness of how Judge Cannon ultimately operates. But recall what's also happened this week. Earlier in the week, Special Counsel Jack Smith had to submit that response to Judge Eileen Cannon's request that Jack Smith engage with jury instructions and hypothetical scenarios under which Donald Trump can declare any of the classified records and nuclear codes as his personal property. Special Counsel Jack Smith responded, "I'm not going to engage with those things. I will provide you with the correct jury instructions that have always been used in cases involving the Espionage Act. The Presidential Records Act has nothing to do with the willful retention of national defense information." So Special Counsel Jack Smith really stared Judge Eileen Cannon down. She's basically backed down by issuing this order now denying Donald Trump's motion to dismiss under the Presidential Records Act. Special Counsel Jack Smith did exactly what I thought he should do. He didn't bite the bait or the trap that Judge Eileen Cannon was setting to engage with unlawful jury instructions. I'll tell you what Special Counsel Jack Smith should do next, because even my younger brother Brett said, "Do you think Jack Smith should still go to the 11th Circuit?" Hang tight. I'm going to give you a great explanation of that in a moment. But let's just take a look at Judge Eileen Cannon's order so you can see it for yourself. Order denying defendant Trump's motion to dismiss superseding indictment based on Presidential Records Act. This matter comes before the court upon the motion to dismiss the superseding indictment based on the Presidential Records Act filed by defendant Trump. The motion brought pursuant to the motion to dismiss rule seeks dismissal of counts 1 through 32 of the superseding indictment based on the Presidential Records Act. Those counts charge defendant Trump with willfully retaining and failing to deliver documents containing national defense information without transmission, communication, or delivery. The motion also seeks derivative dismissal of the remaining counts against defendant Trump, namely the obstruction of justice counts set forth in counts 33 through 38 and 40 and 41. The special counsel opposes. The court heard argument on the motion on March 14th and hereby rules. Fully advised, this is again what Judge Cannon's saying, fully advised in the premises, the motion is denied, bound by the four corners of the superseding indictment. Counts 1 through 32 track the statutory language and essential elements of the charge portion of 18 U.S.C. section 793. So what she's saying right there is, at this stage, I am not allowed to dismiss this based on the fact that Special Counsel Jack Smith used the correct statutory language, and I have to presume as true that statutory framework, and did he use the words is essentially what is being said. So she's not saying, oh, she's basically saying to Donald Trump, look, I have to deny this right now because Special Counsel Jack Smith did what he was supposed to do at the pleading stage, at the superseding indictment stage. But we'll see what happens in the future.
Field of Greens is the healthiest thing I do every day, and I want you on this journey with me. It's literally 1 scoop a day, and it tastes great. Now, I personally love the strawberry lemonade flavor. It's completely improved my life. Now, this is nutrition the way nature intended. When I have my Field of Greens, I find myself having way more energy throughout the day, and I've noticed healthier hair and skin. Field of Greens has helped me with my digestion, and my stomach feels way better, and I just feel better and healthier overall. Now, Field of Greens is radically different. Each organic fruit and vegetable was medically chosen to support heart and vital organ health. Now, I trust Field of Greens to keep me healthy. Now, I promise you're gonna love this product, but if for whatever reason you don't, they'll give you a 100% money back guarantee. I got you 15% off your first order plus free shipping. Visit fieldofgreens.com and use promo code Meidas. That's promo code Meidas at fieldofgreens.com. fieldofgreens.com.
The same counts make no reference, the order goes on to say, to the Presidential Records Act, nor do they rely on the statute for purposes of stating an offense. Pause. Why would they? The Espionage Act has nothing to do with the Presidential Records Act, 18 U.S.C. Section 793. There is no interplay, or as Trump likes to say, interpose between those things. It goes on to say that more generally, the superseding indictment specifies the nature of the accusations against defendant Trump in a lengthy speaking indictment with embedded excerpts from investigative interviews, photographs, and other content. For these reasons, accepting the allegations of the superseding indictment as true, the Presidential Records Act does not provide a pretrial basis to dismiss under Rule 12b, that's the rule for motions to dismiss, either as to count 1 through 32 or as to the remaining counts, all of which state cognizable offenses. But did you see what Judge Cannon did there? We got to be very careful in picking apart her language. She goes, they do not provide a pretrial basis to dismiss. What she should have said is, they provide no basis to dismiss, period, because the PRA has nothing to do with the Espionage Act. She doesn't say that, and she's doing that intentionally to take her finger and poke Special Counsel Jack Smith and to kind of throw Donald Trump a little bit of hope. At the pretrial stage, I have to accept the allegations as true, but once a jury is selected, I don't know, maybe I'll do something and then double jeopardy will attach so that we can't take an appeal to the 11th Circuit. That's what she's doing there. It's nuanced. But if you read these opinions, that's what she's actually saying. Jack Smith knows that. She goes on to say, separately, to the extent the special counsel demands an anticipatory finalization of jury instructions prior to trial, prior to a charge conference, and prior to the presentation of trial defenses and evidence, the court declines that demand as unprecedented and unjust. The court's order soliciting preliminary draft instructions, that's where she told Jack Smith to engage with these two hypothetical scenarios. This is how Judge Cannon's trying to backtrack and protect herself and try to protect Trump. The court's order soliciting preliminary draft instructions on certain counts should not be misconstrued as declaring a final definition on any essential element or asserted defense in this case, nor should it be interpreted as anything other than what it was. It's just a genuine attempt in the context of the upcoming trial to better understand the parties' competing positions and the questions to be submitted to the jury in this complex case of first impression. As always, any party remains free to avail itself of whatever appellate opinions it sees fit to invoke as permitted by law. done and ordered in the chambers at Fort Pierce, Florida, the 4th day of April 2024, signed Judge Eileen Cannon. So you see there, Special Counsel Jack Smith and Judge Cannon kind of sparring, or I should say, Special Counsel Jack Smith dropping the hammer and Judge Eileen Cannon trying to still wiggle out of it. And what she's saying is, look, I wasn't asking you to do anything unlawful here. I just wanted you to engage with these things so we could have this robust dialogue and discussion. So now the question is the following. Can Special Counsel Jack Smith appeal this? And the short answer is no, I think, because he won the motion. Donald Trump's motion to dismiss under the Presidential Records Act was denied. So there's nothing to appeal right now. So and that's part of Judge Cannon's plan. Because what many observers think Judge Cannon is doing, and what Jack Smith called her out for doing, is, hey, are you going to call a jury and panel the jury, and then are you going to dismiss this under the Presidential Records Act? Because once a jury is selected, jeopardy attaches, so then there can't be an appeal to the 11th Circuit, and Trump can't be retried. I think Special Counsel Jack Smith has two tricks up his sleeve for that, or not tricks, moves up his sleeve. The first one, a lot of you have been asking, why hasn't Special Counsel Jack Smith brought charges in another district like New Jersey, where Bedminster is? That's one of the reasons why right there. Shh, don't tell anybody. But I think that's obvious to some. Maybe it's not that obvious, but I think that's what Special Counsel Jack Smith is holding that. Still within the statute of limitations. You see what Judge Cannon does. You have that as insurance, if you will, so that if Judge Cannon makes a bad ruling, you can still charge Donald Trump with other Espionage Act violations in another federal court in New Jersey if jeopardy happens to attach, worst case scenario. But I think Special Counsel Jack Smith remains patient. I think as you get closer to trial, you still wait for Judge Cannon to make a mistake. And then I think right before trial, Jack Smith won't go to trial if he doesn't have clarity from the 11th Circuit. So if this trial's really going to happen, because who knows with Judge Cannon, then I think Special Counsel Jack Smith asks for a definitive statement by Judge Cannon. And if she doesn't give one, then he files a writ to the 11th Circuit, would be my prediction of what goes down here. So here's your full analysis of what happened in this order, what's beneath the order, and what I think happens next. Let me know your thoughts. Hit subscribe. We're on our way to 3 million subscribers thanks to your support. Hit subscribe. Appreciate you as always. Hit subscribe. It's free.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.